Can you continue a case in court? Of course. Happens every day. Tons. Most court appearances are basically continuances. You just show up and it's like, I'm working on and you get a continuance. Why a judge could not be prosecuted for handling contraband during a trial or scheduling a hearing in a matter that inconveniences federal law enforcement officers. What? Like obstruction?
Both those who are trying to come into our country, those who may already be in our country, they are finding the worst of the cartel bosses and making sure that they're not able to continue to wreak havoc and terror in our communities.
A criminally charged judge loses. A big one. This is the case of the backdoor judge, Hannah Dugan, who allowed an illegal alien to exit her back door in her courtroom in the middle of court proceedings when there were victims in the courtroom that defendant allegedly beat. She filed a motion to dismiss her criminal charges. She's being prosecuted in the Eastern District of Wisconsin, and the court just came down with a decision and order, and they are explaining to us what's going to happen next with the backdoor judge. And here's what we've got. They say the court writes, Hannah Dugan, she moves to dismiss the indictment. She was charged with a couple of counts. 1, concealing a person from arrest under 18 U.S. Code 1071, and obstruction of a removal proceedings, section 1505. Now, summarize, the court writes, the government alleges that Doogie, a state court judge, concealed from arrest the apprehension of a person wanted by federal immigration authorities. The lower level judge in this case issued a recommendation that the motion be denied. Okay, so you got magistrate judges, and then this is the actual district court judge. So Dugan objects, requiring me, the next level judge, to review the matter de novo, which means I'm going to look at everything fresh. You want to object, you don't like the lower level magistrate judge's ruling, no problem. Like, I'm the real judge, so then I'll take a look at it fresh with a fresh set of eyes. So she does. When considering a motion to dismiss, the court limits its review to the face of the indictment, so whatever the government says, assumes all facts are true in the indictment, and views the facts in a light most favorable to the government, which makes sense. We're going to give the government every benefit of the doubt. And if you still win and there's no case here, then we have to dismiss your case, okay? Because there's nothing they can do. So the parties briefed, and now we're considering a motion to dismiss. So here are the charges. Of course, the first one was she concealed this person, this illegal EFR, so that he wouldn't get caught by ICE, shoved him out the back door. Did the same thing here. She also obstructed the proceedings. Remember, she went up to ICE. She confronted them. She says, you need a judicial warrant if you want to arrest him. They said, no, giant judge. No, we don't. Upon learning that they had an administrative warrant, she said, you should leave this area and go to the chief judge's office, if you remember that. She also addressed the case off the record. Okay, so this illegal alien in her courtroom who beat people, allegedly, she handled it without calling the case publicly. This is the matter of CR 2025 versus this illegal alien. Any parties' appearances, please? Both sides say, now, do we have victims in the court? Your Honor, victims right there. The victims are in the courtroom here. None of it happened. She just said, why don't you guys come up here to the bench and the podium? They walked right up there and said, we're going to go and move your date. We're just going to do a quick continuance on this thing. We'll bump it out 2 weeks. Do we have anything in April? Yeah, okay, bump it out. And talk to the clerk. Okay, just talk to her. We'll get you a new date. And you, illegal alien, come out with me this back door. And the prosecutor didn't know anything about it. The victims didn't know anything about it. She escaped him. She directed him to use her back door, courtroom 615, and then said he could appear by Zoom the next proceeding so he didn't get picked up by ICE, because illegal aliens get premium version of America. It's like America Max Ultra plan. It's pretty good. You don't have to have licenses or registration. You get free housing. You get free cell phones. Everybody calls you a hero. When you traffic humans into our country, you have a bunch of senators out there supporting you. Free Kilmar. All of them. You have lunatics singing songs like in pink outfits. Free Kilmar. Whatever they were singing. Because they're nuts. They get premium America, baby. Everybody else doesn't. You get tickets. You get arrested. They impound your car. You don't pay your registration. You're driving on a suspended license. Your car's impounded for 30 days. Good luck. You got to go pay thousands of dollars to get it out. Not illegals, though. They call the FBI and they just are allowed to run rampant throughout our country, flipping U-turns, killing and executing families. In her motion, Doogie said that she enjoys absolute immunity. If she wants to let illegal aliens use her back door, she can do it every single day. She's got immunity to do it, and she can do it. She also says this prosecution violates the 10th Amendment, and she said something about vertical separation of powers, which basically got laughed at by the lawyer. He's like, what are you talking about? The magistrate judge concluded that while the Supreme Court did grant judges from civil liability, there was no rule that said you get criminal immunity. She concluded, the lower judge, that the 10th Amendment claim required the assessment of disputed facts, and can't do that in a motion, so we could talk about that if you think it's like a separation of powers problem, but we got to have facts on that. That will happen as the trial progresses, so we can't dismiss at this stage. And finally, the lower judge rejected the constitutional avoidance argument, which was Dugan just saying that this is going to cause a real predicament because we've got the federal government charging somebody who works in a state government, and we just want to avoid those types of conflicts, which is very interesting when their party prosecuted the president 4 times and raided his house. So in her objections, she talks about immunity. She begins with the proposition that every act alleged in the indictment is literally part of a judge's job, so she can just take aliens out the back door no matter what. In other words, they're all official acts, so she's protected. She then says that immunity is not restricted to the civil sphere. It also protects against criminal liability for most official acts, right? So you can actually commit crimes and you're good. She admits 3 exceptions, though, to this rule of judicial immunity. She says if it's wholly unofficial, then it won't count. Like, for example, a judge who murders their wife in their home, or a judge who shares CP on his own time. But what if the judge shared CP while in the judge's robe at the courthouse? Is that protected? Or what if a judge murders somebody? We made this analogy. We said, what if she just shot him somebody in the head right in the courtroom? I executed my judgment. I think the judgment was death, and he's now dead. So I have judicial immunity. Could she get away with that? According to her rule, yes. Graft, or sexual gratification, for which collateral judicial acts are the inducement, so it's like an abuse of your position of power, and official acts that deprive people of their constitutional rights under statutes. If a judge does any of those things, you're not immune. But she says, Dugan, that her case involves none of these exceptions, so I do have immunity. All of the acts alleged in the indictments were done as her capacity as judge. Like, I was wearing a robe. Hello. The indictment alleges no graft or self-interest, such as a bribe or a kickback. Not anything specific, but she was getting her rocks off and getting a dopamine hit for fighting the power and fighting Trump and fighting on the behalf of the downtrodden illegal aliens who beat people in her jurisdiction. And there is no allegation that she violated any individual rights protected by the amendments. And you can make an argument that she violated the victim's rights by continuing the case without having them heard by the prosecutor, violated the state's rights by continuing the case without input from the government. But while the indictment does allege that Dugan knowingly concealed EFR and corruptly obstructed, she says, I'm still immune from the acts. Okay, so my intent may have been bad, but the acts are what I've been charged for. So she might have, corruptly wanted to like win against Trump and stop this, but the acts are immune because she's a judge and she's just showing somebody an exit in her courtroom. So that's immune. And she's allowed to talk to people outside of her courtroom. So that's a judicial act. So all of those things can't be obstruction, even if intentionally she was obstructing, is her argument. The government responds that the Supreme Court has never recognized judicial immunity from criminal liability. And what is she talking about? And that her assumption of immunity inverts the entire analysis. The government says that her creation of categorical exceptions to immunity is an attempt to explain away the many historical prosecutions in a gerrymandered way, one which excludes the conduct here. Okay, so she's cherry picking a bunch of cases and she's like, well, we can create these rules based upon the outcomes in these other cases. And she finds the best cases that are not judges escaping illegal aliens, which probably has never happened before. So she says, well, clearly different than the other ones. They all got prosecuted for these reasons, but that's different. There are exceptions. Now, the government says, I don't know where she made that up from, but even if a doctrine of immunity for judicial acts existed, the evidence in this case will show that she went beyond her judicial role. Instead, they say all events arose from her unilateral, non-judicial, unofficial actions outside the role of a Wisconsin state judge by obstructing a federal immigration matter over which she had no authority. Although the lower level judge allowed that some of the allegations described in the conduct could be considered part of the judge's job, like anything individually might, the judge clarified that Dugan was not being prosecuted for her opining on the fly. That's fine. She wasn't being prosecuted for managing her courtroom or allowing someone to appear by Zoom. Individually, sure, she can make somebody appear by Zoom. Yeah, that's fine. Can you continue a case in court? Of course. Happens every day. Tons. Most court appearances are basically continuances. You just show up and it's like, I'm working on crime, and you get a continuance. So that's all normal. But when you bundle them up together, it was obstruction. She was trying to escape an illegal out of her courtroom. The indictment bundles them together and says it's obstruction, okay? Now, the government concludes that she is not immune simply because she encountered federal agents. And so the court writes, the dispute between the parties boils down to this. Dugan posits as a general rule of immunity that judges are immune. According to the government, there is no general rule of immunity. And what Dugan calls exceptions are simply examples of the types of prosecutions that have been brought against judges. And this judge says a review of the history reveals the government has the better argument. Now, the concept of judicial immunity goes back to 1607 in the Star Chamber. We've talked about it. A judge who presided over a murder trial was was hauled and hailed into a rival court and charged with conspiracy. Okay, so one judge is now said, well, you convicted this dude of murder, and now you're part of the conspiracy, and we're suing you. Lord Cope said, a judge, for anything done by him as a judge, shall not be drawn into question except before the king himself, right? Immunity. Back in England. So relying on this, early American courts granted immunity in civil cases. At times, they even stated the rule more broadly. But the Supreme Court in the United States first addressed the issue back in 1869, a case called Randall versus Brigham, where a lawyer filed a civil action against a state court judge, saying the judge wrongfully removed him from the state bar. Now, relying on this, the court said the judge is immune. So you can't sue him for that. And the court said that's all valid. Now, the court also clarified, though, that this exemption of judges from civil liability cannot be affected by the motives for which their judicial acts are performed, and the purity of their motives cannot in this way be the subject of a judicial inquiry. And we saw a lot of this same concept with Trump, remember, because they can't substitute their judgments in. You know, the president did something for a reason, this judge did something for a reason, and so you're not necessarily analyzing that rationale, because that's what immunity is, right? It's like you are immune from the allegations. It doesn't mean you're only immune if you did it for the right reason. Like, that's the power of immunity. So in other words, you don't have to defend your decision because you're immune from that. Now, in Pearson versus Ray, the court granted immunity to a judge sued under Section 1983 civil rights claim, saying the civil rights protesters were being prosecuted. And the court said that there is judicial immunity in civil actions. Got it. And so in some, there's a long line of stuff that says there is some money damage immunity. But the court, however, has recognized that a judge is not absolutely immune from criminal liability. In fact, in this Virginia case, a state court judge was charged with excluding black persons from grand and petite juries. And in declining to grant habeas relief to the judge, the court spent a lot of this discussing a lot of things, O'Shea, some more case law. So the court acknowledges that granting immunity from damages under 1983 was a little bit different than the one here. And we're also unmoved by the complaint that injunctive relief carried with it the threat of contempt. Now, Dugan is citing two cases. She says, I am immune, and she cites those here, but it's unclear, they say, from her case law, whether the courts would apply the same rule to a case like this, right? Distinguishing these cases, and a lot of it is just going through those cases to just show, Dugan, your cases are not exactly on point. Now, finally, Dugan appeals to Trump versus United States, the Supreme Court decision. This was the three-bucket decision that we talk a lot about. Absolute immunity for the president for presidential duties and responsibilities, presumption of immunity for anything that's even within the bounds of the president's duties. You get a presumption of immunity, and then for things that are clearly not, you get no immunity. So she says Trump is entitled to absolute immunity for his core constitutional powers, and so I should have it too. She says that the court relied on judicial immunity that they extended to the president, right? So she's saying the Supreme Court says judges had it first, actually. The court concluded, based on separation of powers, that immunity was required to safeguard the independence and the effective functioning of the executive branch, right? You don't get to come in and say, well, Trump did that thing for a bad reason. If it's an official act, you don't get to substitute your judgment for that. That's the point. You're not the president, so you don't get to decide. Now, these same concerns do not arise, though, when one of the many nation's judges is subject to prosecution, okay? The president has constitutional duties, and we can't let that person be attacked. But further, while the court relied on a previous decision in Nixon, which granted the president immunity from civil damages, the court said nothing, right? That was absolutely true about criminal immunity for judges, and we read through that decision in detail. Now, ultimately, as the Supreme Court has stated, the officials seeking absolute immunity must show that they're entitled to it, and Dugan has not done so here. This is not to gainsay the very real concerns that she raises. She wonders why. If official acts enjoy no immunity, why a judge could not be prosecuted for handling contraband during a trial or scheduling a hearing in a matter that inconveniences federal law enforcement officers. What? Like obstruction? Okay, now saying that is not the way to the criminal justice system operates, and this is common sense, she says, is just unsatisfying, so that's not good enough. As the 11th Circuit noted in permitting a prosecution of a judge for bribery, this is not a case in which a judge has been prosecuted for official acts. In a case, there may be a common law immunity. If it was official, there might be immunity, but this leads to the government's fallback position, saying she's not being prosecuted for official acts in the ordinary course of her duties, not even charging her for those. Instead, the government says the events alleged in the indictment arise from her unilateral, non-judicial, unofficial actions outside the role of a judge. Now, while it would be improper to consider facts right now outside of the indictment, this is a motion to dismiss, not a trial in the papers, viewing the facts that are alleged in a light most favorable to the government, argument, since we might be ruling against them, as I must at this stage, and accounting for the indictment's allegation that she knowingly concealed this illegal and acted corruptly, I cannot say as a matter of law that her conduct falls within even this more limited version of immunity that she claims exists. There is no basis for granting immunity simply because some of the allegations in the indictment, conduct that could be considered part of a judge's job, right? Just because, like, yeah, you can manage your calendar and yeah, you can issue continuances. That's all true. But you did it in the facilitation and the obstruction of a federal arrest. As the judge noted, the same is true in bribery, where judges were prosecuted for bribery. Now, Dugan argues that the gravamen of the offense is the bribe, right? It's got to be something more than just letting him escape. But the cases don't support her distinction that she's trying to draw. Or, as the government puts it, a judge may use judicial acts or tools as means to accomplish an unlawful end. And to the extent that Dugan says that the act requires Judges Act for self-gratification, like if you're going to charge her, it's got to be she wanted to get rich or she wanted to go, get some financial benefit. There's no authority for that proposition that the motive must be financial for it to be corrupt. She was excited as hell to be a part of the resistance. And to the extent defendant contends a court cannot inquire into the motives, the same could be said about bribery cases. And even if a more limited version of immunity exists, it doesn't support dismissal of this indictment. And so next, her 10th Amendment argument. She cites no authority for the proposition that federal criminal statutes may not be applied to state court judges, right? Now, it's true the Constitution does establish a system of dual sovereignty, right? In 10th Amendment, anything that's not in the Constitution is reserved back to the states. And so I think she's saying that I am not officially approved to be prosecuted. You are prosecuting me. And so that's a separation of powers problems. Now, although the states surrendered many of their powers to the new federal government, we do have a federalist system. We've got two federal and state governments, but the state law permits judges to be prosecuted, of course. While this case involves the routine work, she says, it's not something that can be decided right now in a motion to dismiss. The state law permits discipline of judges for ethical violations, and the rules don't preclude the bringing of federal charges against you under the 10th Amendment. She cites some other cases. And then finally, Dugan talks about avoidance, just saying, well, we don't want the government fighting with itself. The canon of constitutional avoidance comes into play only when, after the application of textual analysis, a statute is found to be susceptible of more than one construction. In other words, you can read the statute multiple ways. And when you read a statute, like the statute is written poorly because our congresspeople are idiots, you interpret it in a way that's not going to cause more conflict. That's the avoidance. Not this. She cites no case finding these terms would apply here. And in Snyder, there was a different decision. And so it is therefore ordered. Judge Dugan loses. The magistrate judge's recommendation is adopted and Doogie's motion to dismiss is denied. It's further ordered this matter scheduled for another in-court hearing on Wednesday next week. Good news here that this illegal alien was actually caught by ICE and hopefully is being processed for deportation, and his co-conspirators like Doogie are getting prosecuted. But the problem is much broader. And here is Tulsi Gabbard from the Oval Office cabinet meeting explaining what's coming next for the cartel bosses and what's happening with the DEA and FBI all across America.
She's becoming a bigger and bigger star every day. You found a lot of good things. Go ahead.
Thank you, sir. As we approach Labor Day weekend here, this is just such a great opportunity really to recognize your leadership as a true champion for working people. And I know we'll hear as we go around the table here how your focus singularly on putting the well-being and interests of the American people first is that common thread that we're seeing in your policies being implemented across your administration. For ODNI, number one, our focus is and must always be making sure that our intelligence community is focused on our mission, keeping the American people safe, secure, and free. We're doing great work on this front. I'll point out our National Counterterrorism Center, led by Director Joe Kent, are working across different agencies with Homeland Security, DEA, FBI, and others to catch terrorists, both those who are trying to come into our country, those who may already be in our country. They are finding the worst of the cartel bosses and making sure that they're not able to continue to wreak havoc and terror in our communities. Secondly, Mr. President, you have charged me with the mission of finding the truth and telling the truth to the American people. And we've exposed some of the worst examples of the weaponization of intelligence in the last several weeks. I will continue down that mission and that path wherever it leads. Transparency, telling the truth is what will drive true accountability for the American people who deserve nothing less. And lastly, Mr. President, all of us are charged with being good stewards of taxpayer dollars. I've gone through a reorganization for ODNI that we've announced last week. We've cut nearly half of redundant, unnecessary functions within ODNI, saving saving taxpayers over $700 million a year. We will continue focusing on our core mission in keeping the American people safe and appreciate your leadership and your focus on this most critical task.
Yeah, Tulsi Gabbard. All right, so we see the administration is firing on all cylinders, the DOJ winning motions to dismiss against the backdoor judge, and it's actually going to be curious if this case goes to trial, right? We're going to see if she wants to have this all splayed out in front of the public to see. She's got a court date coming up next week, so we'll keep our eye on this one. But in addition to what's happening domestically, Tulsi's helping to look around the rest of the world to go after the cartel bosses and make sure our country is safe, and we appreciate the work for once caring about America's border and American integrity, and we'll keep our eye on this case.